Welcome back, everybody. I hope everybody had a good break. Enjoyed what Hotel Kohinoor has to offer today. So I welcome you back to the second session today. Uh, and as professionals, we are interested with financial integrity and also ensuring compliance. And while complying with various sections and the provisions of the Act, we forget that there are many benevolent provisions also, which we can take use of and give added services to our clients. So today, Advocate Ajay Singh is here, and he will take us to the benevolent provisions of the Income Tax Act and how we can take benefit of the same. So these offer reliefs, incentives, and support to taxpayers, and they are often underutilized due to lack of awareness. So we are privileged to have esteemed speaker, Advocate Ajay Singh, who will share his expertise in helping us strengthen our professional acumen. I encourage you all to engage actively, ask questions, and make the most of this opportunity which we have with us. So let us not delay and begin the second session. To give a formal introduction, I request our coordinator of the day, CA Megha Safle, to introduce our learned speaker. Thank you.
Thanks, Vijitaji, for giving me opportunity to introduce Dr. Shri Ajay, Advocate Ajay Singh. As you must be aware, he's a good, very good speaker, and we don't need much introduction, but still, as a formal note, I'm introducing him. Shri Ajay Singh, advocate, Bombay. He's a Bombay High Court advocate and LLB. He has done LLB, LLM from Mumbai University. He has joined the bar in August 2000, and since then he's in professional practice. He has associated with Chamber of Late Shri K.R. Dhanuka advocate, Shri B.V. Javeri advocate, and Dr. K. Shivaram senior advocate. He is practicing independently since 2015. He is practicing before Supreme Court, High Court, Appellate Tribunal, then Commissioner Appeal, and appearing before Metropolitan Magistrate Court. His main practice of area include domestic tax, search and survey matters, international taxation, transfer pricing. He also specialized in drafting and appearing in petition, appeal before High Court and SLP, drafting wills and agreements, consulting in real estate transactions and cooperative societies. Advising clients on direct tax issues, Benami laws, prevention of money laundering, prosecutions, etc. Then even he has filed and associated with various public interest litigations on issue concerning tax professionals and contributed articles and papers for various professional journals and magazines. He is also co-authored in various books on taxation, allied laws on various subjects like reassessment laws and practice, interpretations of taxing statutes, search and surveys, etc. And he has delivered lectures and presented papers to various professional bodies across India, taking active part in various professionals and social organizations, editors of AIFTP journals of 2023 to 25. He is also vice president of ITAT Bar Associations, then joint secretary of ITAT Bar Association Mumbai in 2021 to 24. He's past president of Chamber of Tax Consultant for the year 2017 and 18. Right now, he's advisor of Student Committee of Chamber of Tax Consultant. With this brief introduction, I just request CA Jesh and CA Pinky Kedia to give a formal formal mementos for me.
A very good morning to all of you. It's wonderful to be here at JB Nagar. I'm coming here after a long time. Thanks to Pinky ji, Vijeta ji, Jayesh ji, Anil ji. And by coming here, I am also able to meet old friends. Many times we just meet for some matters, and thereafter there are no litigation with the particular charter. It is a good thing, but they don't meet thereafter. So these are the places where at least we have a good interaction and we meet old friends. So thank you, JB Nagar Study Circle, for this opportunity. Friends, coming to the topic, actually Pinky ji asked me to that I have to deliver one lecture again and very short time. And then I said, what I will see? She said, you speak on judgments. I said, no, judgments are, I have to prepare it. I will take more time. So I just spoke, can I speak on this? And she said, yes, the audience will like, and therefore I chose this topic. I don't know how far it will be useful, but let's have an interactive session. You can put your question as and when you feel comfortable. Though I have prepared a detailed article on this, which you can go at leisure. There are judgments, there are various topics, but what are the main topics for discussion? I will put across, and you can have your queries raised, whatever is there. Okay, so before I start, let me ask how many of you have exercised this provision of section 264 anytime in your practice? Okay, not more than 5 to 6. 5 to 6. So very underutilized this provision. So let me first introduce you to this provision. What is this provision? Okay, so as you see, in our body, we have various organs, right? Every organ has its own function. Similarly, if we compare the Income Tax Act, it has various provisions for charging section, machinery section, definition section. But there are few sections which we don't read because we don't feel the need of reading those sections. Because while making your return, you're preparing your return, filing your return for assessment, you don't require these provisions to read. These provisions are like Sanjeevni Booty. When nothing helps, then you have to look upon this section. So many times we criticize the act. ये act तो ऐसा है, इसमें कुछ है नहीं, it's not properly implemented. But when the framers of this act originally framed the provision, they inbuilt certain safeguards also. Unfortunately, we don't use it. And the second unfortunate is that department don't invoke that. Whenever you have to apply, you don't invoke, and therefore it is underutilized. But I will say this is a provision, something similar to that. It is a saving when you don't have any remedy left. Then you can look upon this provision to seek your remedy. So this is that provision which is there in the act, which one should read and at times you can utilize. How many of you have faced a situation where you have filed an incorrect return? Kuch income, kuch expense, or some treatment you have given wrongly, and later on after your assessment, your return is processed, or your assessment is completed, you feel, hey, this is something wrong. How many of you have faced this situation? Many of them face, right? So what we do, assessment complete ho gaya, 2 saal ke baad malum pada, okay, this is there, what you do? You leave it. Client also, you don't say, who will tell the client? Client will think, why we have done, again, complexity will be there. Yes, if the assessment is there and you are in appeal, then you have a remedy that you may add an additional ground, an additional claim, and you can continue with your claim. But if there is no appeal, then what to do? Your return you have filed, department has accepted. If there is some refund, that is also issued, chapter is closed. After 1 year or 2 years, you come across or meet somebody or some judgment is there, and then you are, my interpretation to that particular aspect is wrong. Or in the subsequent year, when you are filing the return, you go back and see, oh, that treatment what I had given to a particular receipt should have been a different way. Instead of revenue, it should have been a capital receipt or something like that. So we are stuck. This is a section which helps you out in such a situation. Okay, so let's go through this. And so don't confuse this section with the appellate section. Excuse me, let's go scroll. So, yes, thank you. So don't compare this section to as a appellate section. When we file an appeal, what a jurisdiction has with a appeal authority, the same jurisdiction is not with a commissioner when he is exercising 264. Mind it, it has some aspects of an appellate authority, but not all. In an appeal, the CIT appeals or the appellate authority has a more wide jurisdiction. Whereas under 264, the powers conferred on the commissioner is very narrow. So I will also like to read, because many of you have not invoked this. So just let me start once. थोड़ा सा आगे बढ़ते हैं, फिर क्वेरी लेंगे एक बार. So let me go through this section once so that we all are together while understanding this provision. So where can we invoke this section 264? So the section reads that in case of any order other than an order to which section 263 applies, passed by an authority subordinate to him, the principal commissioner, commissioner or so and so, may either on his own motion or an application by the SSC for revision, call for the records of any proceeding under this act in which any such order has been passed, and may make such inquiry or cause such inquiry to be made, subject to the provision of this act, may pass such order thereon, not being an order prejudicial to the SSC as he thinks fit. This section has been named as revision. 263 is revision. Many times you must have faced commissioner exercises. 263 says that your order passed by the assessing officer is erroneous or prejudicial to the interest of the revenue. This section is exactly opposite. It says, the last sentence says, he may pass such order thereon, not being an order prejudicial to the SSC. That means when this provision is invoked, the commissioner cannot decide something against you. He may reject your application, that is a different thing, but he may not decide something against you. He can only decide in your favor or reject the application. Okay. The first part of this section, what it says, in case of any order. Okay, it's case of any order. So any order which is passed by the income tax authority, this 264 can be invoked. I am trying to, what I am doing, I am breaking the section and putting part of that. Okay, फिर उसमें से issues रहेंगे, then we will take up that issue. So one, that he cannot pass an order which is prejudicial to the interest of the SSC. He can, this provision can be invoked to any order. The only requirement is this, the order should be by an authority which is below that commissioner. So anything who is below the commissioner passes an order, you can invoke 264. Who can invoke? Department, commissioner, or the SSC. Normally 263 is invoked by the commissioner, but it is for their interest, because they want to say my assessment order passed by the assessing officer is erroneous or prejudicial. Here it is on his own motion or on an application by the SSC. So in my practice of last 22 years, I have never seen department invoking this provision. That is unfortunate. But SSC can invoke. So SSC need to invoke this provision and then the commissioner will exercise. Many times when these applications are filed, I have appeared before the commissioner. They are also surprised that what is this provision they have never seen. Then I have to explain them. And with help of the same article, I give it to them, sir, you go through it, then we will have the next hearing. So it is not that you, but many times the department officers are also not aware that, yes, there is some provision like this. So either on his own motion or an application by the SSC, call for the records of any proceedings. So it is necessary that when he invokes this provision and the commissioner wants to look into the matter, he should call for the records of the proceedings in which any such order is passed and make such inquiry or cause such inquiry to be made. So he can also make inquiry. So if your application is there and he feels some point to be referred or some inquiry to be conducted, he can look into that and get an inquiry conducted. And thereafter, he will pass an order. So if you will compare this provision it is has such a wide, अभी आपका जो सिचुएशन आप अभी सब लोग सोच रहे होंगे अरे मेरा वो वाला केस था वो वाला, अब उसमें आप सोचिए कि this provision if we invoke, can we invoke and can the SSC seek some remedy? Okay, so it has such a wide power, nothing is going to harm the SSC, but if something you have left out or something you have wrongly given a treatment, you can certainly reverse it by making such an application before the commissioner. Now there are some further conditions, just we will hurriedly go through the section. He can invoke on his own motion or the SSC's application. The only requirement is that you have to invoke this provision within a period of 1 year from the date when the order was passed. What if the 1 year is gone? Can I make an application, belated application? Answer is yes. You can make a belated application also. Subsection 3 states that in case of an application revision under this section must be made within 1 year from the date on which the order or question was communicated to him or the order in which he otherwise came to know, or it is whichever is earlier. If there is a delay, you can make an application, show sufficient cause, get it condoned, and your application will be entertained. Then they question that which are the orders where you can not invoke this situation. So if you have filed an appeal before the commissioner appeals, can I go for revision? Answer is no. If there is a time limit for filing the appeal, can I invoke this provision within 30 days? No. Once the time is expired, only thereafter you can invoke this provision. Wherever 263 has been invoked, can I invoke? Answer is no. If the already some commissioner is exercising the power under 263, you cannot invoke. Or the matter is pending before CIT appeals or ITAT level, you cannot invoke such matters. You have to pay only 500 rupees as a challan to filing of this, and the commissioner is directed that this application should be decided within a period of 1 year. This is a direction and not mandatory. So within a period of 1 year, nowadays I have seen, yes, the applications are taken within a period of 1 year. Earlier, many times when this application was filed for 2 years, 3 years, the matter used not to be taken. But now I have seen that last 2 or 3 years, matters are being taken within a period of 1 year. The last point in this is that this order, once the commissioner passes this order, there is finality. There is no appeal which is provided under the Act. What is the remedy if you are not satisfied with this order? You have to file a writ petition before the High Court. Okay, so this is the basic provision under which this section is invoked. Okay, now I will proceed further. Now, if you have some questions, sir.
Is section 264 the concept of total merger and 263 concept of partial merger?
Sorry, so
Section 264 is the concept of total merger.
yes, total. You cannot go partly. You have to go full against the full order. You cannot say partly I will go for appeal and partly I will go for 264. You cannot do that. Okay. Yes.
If we apply for 264, can commissioner initiate 263?
If you apply for 264 and can the commissioner invoke 263? Again, 263 will be on a different subject matter. It is an independent jurisdiction. Okay, where he will try to pass an order stating that the order of the assessment which is passed is erroneous or prejudicial to the interest of the revenue on any particular issue. Whereas your application is for something else. So it cannot be simultaneously for the same thing. You are going for a different relief, and what he is invoking is for a different relief. Right?
When we apply for 264, the commissioner asks for a complete scrutiny of the case.
No. No. As I said that there cannot be an order which is prejudicial to the interest of. So for example, I go for a particular claim that this particular receipt I have offered to tax. I have wrongly offered to tax. It is actually a capital receipt, and there are the jurisdictional High Court or the Supreme Court decision which has confirmed, department has accepted. I misunderstood and I filed the return. You want to make your return, correct your return. So when you apply, he will either accept or he will reject. He cannot do any third situation.
These CPC Bangalore orders can be revised.
143(1) orders can also be, because the section says any order.
Yeah, but is CPC Bangalore below the principal?
Yes. Yes.
Tax credits.
Yes. So I have in my I have listed down scope. So if you all permit me, I will just move further. Some questions will automatically be resolved, but you can still raise your query. So it depends upon case to case, but for example, the assessment order is there, and there is some claim which you have missed to make a claim. And the assessment order is passed, nil, accepted, and there is nothing, and there is no dispute as far as your claim is concerned. Then you can very well exercise 264. But if there is some issue relating to your claim and there are two views possible, or there is something which is required of verification or application of mine, then I would suggest you go for an appeal. So it depends on the point of time when you want to seek and when you come to know I have missed this bus. So if you are standing at the station, you miss a train, I will always advise wait for 5 minutes, the next train will come. But if you come to know that no, there is some problem and there is a block or there is a subsequent trains are not there and you are left, there is the last train, then I will say immediately book Uber, get down, take the Uber and go. So it is something like that. It is which point of time you come to know that yes, this is a claim, I have missed it. Everything, anything. Yes.
File the return. And we know there are the mistakes, but filing, it is revise option is also not available. Then we can go for this.
So again, there is another part of this lecture where I am dealing with section 119, 2 small b. So many times relief you can seek under that section also and this provision also. It depends again what is the nature of relief, what is the issue, and accordingly we can advise. So when I will come to 1192b, I will deal 1192b basically is a relief which is provided by the CBDT. When the act closes your door, closes the window to seek any relief. For example, you have missed to file your return of income under 139 in particular time. There are certain consequences if you don't file your return in time, right? For a simple example, carry forward of losses. You are not entitled. Now, for some reason, your return has been delayed. Now, what to do in such a situation? Your carry forward loss will go, your refund claim will go, all these issues are there. Then the correct provision to invoke is not 264, but correct provision to invoke is 1192b. Make an application to CBDT, get your application condoned, delay condoned, and thereafter your return will automatically process, right? So there are two situations. You have to depend on case to case which one to invoke. So let us just run through this slide. So scope of revision jurisdiction. The order should have been passed by an authority subordinate to the commissioner. Any order other than 263. Commissioner can act suo motu within 1 year from the date of the order. SSC can make an application. Application cannot be entertained prior to expiry of time limit for filing an appeal is available. As I said, if seeing the nature of relief, even if there is some delay, I would advise a client to go for an appeal with a condonation application because then the scope is much wider. But if you have a very clear-cut case and you feel that this case doesn't require any adjudication, but it is only that you should accept that my return some claim is wrong. Otherwise, it is allowable. In such a situation, you should go for 264. Belated application cannot be entertained prior to expiry of time limit for filing appeal is available. Belated application can be considered. It should be accompanied by an application for condonation of delay. Commissioner should condone the delay on belated application on sufficient cause being shown. Revisional authorities cannot be exercised if appeal is pending. Once the CIT appeal tribunal exercises its appellate jurisdiction, revisional power comes to an end. No order can be passed under this section, which is prejudicial to the SSC. This is very important. Revision jurisdiction under 264 is subject to the provision of this act. It should be exercised in the interest of justice. You cannot ask a relief which is beyond the Income Tax Act. You have to restrict yourself within the limits of the act. Principle of natural justice has to be complied. So once you file this application, you should will get a hearing in this matter. Revisional orders passed is not appealable. So once the order is passed, it attains finality. The only remedy is left to go in writ before the High Court. For exercise of power, 264 is not a requirement that the order has to be erroneous. So you will find cases where you make an application under 264 and the commissioner will say what is wrong in the order which is passed. For example, 143, you have filed a return, the return is accepted. Okay, you make this application, the first question the commissioner will ask, what is wrong in the order? आपने जो फाइल किया हमने accept कर लिया. Why I should exercise? So the requirement is that the order should not be erroneous. It is not necessary that order should be erroneous. It can be the order is perfect, correct. It is processing my return what I have filed, but it might be because of my own mistake. I have missed to claim something or I have wrongly claimed. Still, the jurisdiction has to be exercised. Also, one point, as I said, many a times this provision are invoked where there is a delay and there is a delay. So you have to file a condonation application and show sufficient cause. To my experience, when this provision and this applications are invoked, the commissioner will try to see how I will reject this application. The easiest way, how should I reject? And one of the easiest way is say that you have not shown the sufficient cause. So 90% of the time I have seen they invoke that your application is delayed, your condonation application which you have filed doesn't show the sufficient cause, and therefore I will reject. So it is easy for them to reject your application without dealing with the content or your merits. So you have to be very careful when you are filing a condonation application. Don't just file generally. You have to show sufficient cause, some reason. There are ample of judgments on condonation. The same principle will apply here also. So, but your reason has to be there. Something has to be there on that. It may be genuine reason, mistake. So one of the law in condonation is this, that in all cases of condonation, there is some mistake on the part of the SSC. There cannot be a case of condonation where there is no mistake either of the consultant or the SSC or something. कुछ तो हुआ होगा ना, time पे नहीं किया. So you cannot look at those application in that way. Arey, you have committed a mistake, so I will not condone. The law is not the way. The law on condonation is there. What you have to see is whether the SSC is coming with clean hands or not. Whether he is playing some tactics to purposely delay the matter, is something else, his malified intentions is there. Something like that should be there. So always in your application, try to discharge this burden on your part. So deal with that, file an application. According to me, it should be accepted even if you have filed a belated application under 264. And he will have to deal with that. Yes.
They always reject the application.
So I will tell you practically my experience is there. At least I have come across or I have dealt with around more than 10 to 15 matters where they have rejected on the ground of condonation because the matters are substantial, and at the time of filing the SSC, and we are aware that we have to go to the High Court for this. So we file with keeping in mind that they will reject. They reject, we go to the High Court and it is allowed. So many times it is allowed on the merits of the case itself. So recently, so there was a case I will tell you where the SSC has wrongly claimed the compensation. I would not use the word compensation. It was a case with a builder where the SSC and his wife had booked 2 flats. And there was a normal dispute and delay in the delivery of the possession of the flat, and they filed a suit before the High Court. The matter went on for some time. A new developer entered in the matter and he said, we would like to settle the matter and close the matter. And ultimately, they filed a consent term before the High Court to settle the matter. There were two parts of the money. What was agreed to be paid to the SSE was the principal amount, and the second part was interest. Now, what is interest? Basically, the additional thing or the additional value that flat would have been, if the flat would have been received by the SSE, it was quantified in the terms of interest. Other part of that interest, what it could be, the compensation or the hardship. So those words hardship, compensation is not used in the consent term. Okay, the word used is interest. What is interest? It is the manner in which we will compute what is the additional amount the SSE has to receive on the principal amount what was deposited with the builder. So there was no word compensation, there was no word hardship, there was no word additional or something like that. It was the word interest. TDS was also deducted on that. The SSAs, whoever consultant was there, they filed their return. Principal amount received, the principal no tax, the interest income from other sources. TDS deducted, income from other. After a few years, when the consultant for some other matter came, and I was discussing that with her, sir, what is this? So I said that this is a matter when in some other matter, I am trying to say that interest, don't use the word interest, whereas so and so, some consent term was to be vetted by me. So I added, then said, no, there was one case where I have filed, my return is accepted, but you are saying it will be a capital receipt. I said, I'm not saying it will be a capital receipt, but it can be capital gain or a capital receipt not liable to be taxed. So after we did and then said, no, we will file 264. Then we filed and then we brought out this particular position that what can be this amount be treated, which is referred as interest, and TDS is also deducted. See, interest under the income tax is defined. Where interest is where a debtor-creditor relationship is there. There is a debt. This is what the amount what I had given to the builder was a creditor-debtor relationship, a principal borrower some relationship. No, it was a purchase transaction on which the interest has been paid pursuant to a consent term arrived. The terminology or the nomenclature is given as interest, but it is not actually an interest. There is also a law when the payer and pay is there. What the payer is treating, giving a treatment to a receipt, it is not necessary that the other party will have the same treatment. So we filed this application, say that this is a capital receipt. Alternatively, it is a capital gain. I had deposited 1 crore. Now I am getting 1 point some amount. It is a capital gain. You compute capital gain because in computation of capital gain also SSE was getting a good relief and hardly something was coming. If filed, the commissioner accepted. It was accepted at that level itself. Unfortunately, in the case of the husband, it was not accepted. The same issue, same flat, same order, same thing, it was not. For that, we are in the High Court. So what I'm trying to say, so there are sometimes this law and this you have to balance and then you have to take this forward. So I would take a conservative view. I would take a conservative view and I would say treat it as a capital gain. So what you have a right, you have an agreement. Once your agreement is registered, you have a valuable right. You have a valuable right. You have a right for specific performance. Because you had a right, therefore your suit was maintainable. Because your suit was maintainable, there was a consent term. The interest component is not given to you that way. The interest, how you will in any case, let's take a case of a motor accident. How you compute the compensation? There is some way methodology which you have to adopt. Interest is one of the methodology to adopt and quantify the amount. Because the nomenclature is used as interest, it doesn't mean it is interest, because what interest I have to see as per the Income Tax Act. And there is no debt that it will be treated as interest. There is no borrower relationship between the buyer and the builder. So what I am trying to say, this is how we need to look at each case and thereafter you have to take a call on that. So at that time, the payer was there. He had treated as a consent term. He will protect himself. He will deduct. He will protect. Why he will wait for you?
deducted on the compensation they give actually.
Where?
Many cases.
Yeah, so it depends which forum you are there. So if you are before a, so if you are before a RERA authorities or you are before a consumer court, so there the working of the amount which you have to receive, they refer it specifically as compensation, additional amount, depending on what is the value of that particular property as of today. So there are different way of computation. But at times it may happen when you are having a consent term, you may miss all these things because at that time your intention is to take the money, right? So all these calculations are there. So at times it happens that SSCs slip this particular aspect and it may have a different treatment, but later on you realize this. Okay, so this is the remedy. I'm just giving you an example that in such a situation, this is one of the remedy. So as I said, taking a conservative view, I would advise that take it as a capital gain because the word compensation is nowhere mentioned in the whole order consent term. Had the SSC been more properly advised and he would have included the word compensation in the consent term, yes, then the matter could have been different.
It is a capital receipt.
But now it is deducted in the other section and we are treating it as a capital gain, other complication will arise.
No, the credit you will still get. What is the problem? Just because the other party has deducted the TDS under the wrong provision or the wrong head, it is necessary that I should offer it in that. The law is not this.
One more case, suppose in bank, this 4 pays you interest for delayed payment of rent, then it becomes income from operation.
Again, it should be taken from rent. It takes the nomenclature and color from the principal amount.
50%.
Yes, ma'am.
It as long term or.
Sorry,
While computing capital gain, will treat it as long term or short term.
what? Depends upon when you have booked the flat.
That period is the dispute period. It will be.
Yes. So if you take it simple way, your flat you had booked for 1 crore. After 4 years or 5 years down the line, there is a dispute. You don't get a delivery of the flat. You go to the court. In the 6th or 7th year, the court directs you, you pay him 1.50. So what is that extra 50 you are getting? The additional, the value, what are the particular flat would have fetched on that particular day, something around that. That is what the methodology is there. Otherwise, why you will agree for 150? There is the reason, some reason for why you have agreed. So what is this? This is the additional component, what it is there.
But
Right.
the word compensation is there, then it is.
Then you have to quantify it and then you can treat it as a capital receipt.
Then, when CIT is already expired, where Sriram filing after you CIT is the condonation of delay. And the CIT has to change that condonation. Then would I can file to ITAT in that order?
Yes, you can go.
Did not go to the
264 again, if you're, so let me put your question. What his question is there, that if I have filed an appeal before the CIT appeal and for some technical reason, my appeal is rejected. Can I go to 264? Answer is yes. You can go. If your appeal is rejected on some technical reason, then yes, you can go in to 264. Sorry.
Validators must be taken by CIT.
Huh. Therefore, you can, because the appeal is itself was not maintainable, and therefore you can go in appeal, 264. Again, I would say it depends on fact to facts. It depends on facts of each case.
1 year will count after I receive CIT appeal order.
No, 1 year will have to be counted from the original order. You are not challenging 264 against the CIT appeal's rejection of condonation application. You are challenging the main order. The same fate, yes. Yes, but many times it depends what is your issue is very crystal clear. There is no adjudication or something and you feel going to ITAT, it will be more time or something. You may have a different, you will prefer to go here. So again, I said, it depends on each facts of its own case. So expression, oh, yes.
Can a matter be remanded back to the ITO in case of application under section 262?
So if I read the section, subsection, they empowers, subsection 1 empowers that the commissioner can do inquiry by himself or get an inquiry done. So normally what happens when we file this application, the commissioner calls for a report from the assessing officer. After he receives the report, he looks into it. Thereafter, he has to decide the matter. Maybe for the computation purpose or some general thing, he may send it back. But he will not send the matter on merits to be decided by the commissioner. He has to decide the matter and thereafter he will send it back.
The report can be called, but case cannot be remanded.
No, case will never be. He has to decide the case. The authority who has to decide is the commissioner. Once he decides the case, thereafter for computation purpose, something like that, or to give effect to that order, he may send it back to the officer. Yes.
What is the meaning of rectification of mistake? 264 or I will
Sorry.
rectification of mistakes is sometimes submit to the mistake.
So rectification of mistake is 154, where there has to be mistake apparent on record. So let me give you an example. You file a return. Let us take the same example what we are discussing. You file a return whereby you show this interest which is received pursuant to a consent term in a case of a builder and SSC which has been disputed. You offer it under the income from other sources. If you will, the return is processed and accepted. Now you will file 154. Why the assessing officer will deal? Where is the mistake apparent on record in the order? Why he will exercise 154? There is no mistake in the order. Can you file an appeal? Answer is, to file an appeal, you have to be an aggrieved SSC. Are you aggrieved? So all this problem comes when you go through an appeal of 154. Under the Income Tax Act, there are different provisions. Some provisions are overlapping, but there is a clear-cut distinction. There is 154 for rectification. There is 263 for revision. Order has to be erroneous and prejudicial. If your income has escaped assessment, then 148 is there. So there are different provisions, different ammunitions are there with the department to be invoked at a relevant point of time in the particular situation. At times there are overlap. I agree. At times there are overlap, but there is a clear-cut distinction as far as powers are concerned under 154, 263, 148. If there is a mistake in your order, the first thing is that you should invoke one department or anybody will invoke 154. But if there is no mistake apparent on record, then probably 154 is not the right remedy to be exercised. Right, sir? Yes.
148 AD order passed by the assessing officer.
148?
AD order.
Right.
Not taking into account what submission I have made.
Yes.
Now I filled 154 application with the same officer.
Yes.
He says I cannot pass any order for 154 because I had an approval of CID.
Yes.
Now, when the justification for any order passed by the assessing officer can be rectified. And then the IT judgment also can be, IT also had with non-consideration of any record is a mistake apparent from the record. So can assessing officer refuse to give the rectification?
See, the question is not can. Are they doing it or not? They are not doing it. Why? They are saying when my final order will pass, you will challenge that order and you can take whatever grounds are there. But at that particular juncture, I will not exercise that power. They can, but answer is they are not doing it. See, there are many things they can do, but practically you have to balance both the things. You have to balance both the things. You file 154, but there will not be any purpose. Yes, madam. I don't think so. I will have to go through the slides. That is good for me.
The rectification under section 264.
Yes.
Like officer has two options, either to give in our favor or reject them. If he finds some grounds, he reject the thing, but can he issue us any notice under appeal or scrutiny or something?
No. As far as your application, he cannot do it. What he will do it? Let's, if you are saying what he can do, 264, 263. 263, there is a time. There is a condition that it has to be erroneous or prejudicial to the interest of the revenue. So there has to be, these conditions will have to be satisfied. If that condition is satisfied, then probably he will invoke. Then you have to balance when you are filing this application, how you deal, what are the other issues. Is there something else, what you have to disclose, what you have to put across, what you should not put across. All this factor you have to take and then go. Yes, sir. You can seek everything under 264. It is any order. But as I said, that you have to see whether there is any two views, difference of opinion, and what are the exactly the powers what you want the commissioner to exercise in your favor. Just you will say, no, this is a case where assessing officer has made this addition. I want this penalty should be deleted. He will say, no, he has rightly leveled. What you will do? Then you will go to High Court against that. The better remedy is that you go to the CIT appeal. If he is little liberal, if he had a good day in that day, he will delete your penalty. If you have a bad day, you come to IT-80. 90, I would say 95% of the cases where penalty is levied, tribunals do give relief, provided you put forth your proper submissions and across. So your case will be some or the other technical point you will remove. कुछ नहीं मिलेगा कि notice में strike नहीं किया. So something or the other we have. So the lawyers have this habit. Some or the other reason they will do. As our assessing officer is doing now, we also do the same thing with them, but at the right place.
Sir.
Yes.
SSC comes and say, I don't have anything to submit. You only find out technical problem. I don't ask me any questions and no facts. Just ask the technical fault and just file a bill. That's all. Ask the question, anything I will tell, but no facts, please. And that is what it is. It is right here only, it is what. Please.
No, half of my slides are done. I have to just, if you want me to scroll, I will scroll. Otherwise, half of the is done. And yes, sir.
Once in lifetime penalty can be controlled.
Once in lifetime, that is a different provision where waiver is there. Okay, so very rarely that will be exercised by someone. Okay, so that is a waiver of penalty. You have to satisfy the other conditions in that, and then only it will be done. So in all the cases, you don't expect. So let's run through this. Okay, whatever we have discussed, the same thing may come up here, but we will just have a cursory. Something is missed out, I will just deal with that. Okay, expression order. For the purpose of 264 as a wide connotation, it includes determination by the assessing officer and application under 197. So these are the basically different provisions where the commissioner this can be invoked. Okay. A petition for revision may be made against order which are not under the statute appealable. So wherever there is no appeal provided against any particular order, we can go in 264. Revision against intimation under 143(1) maintainable. Somebody raised this question. Yes, it is maintainable. There are decisions of various high courts. Okay. You can refer to that. No prejudicial order against the SSC. We have discussed. Commissioner cannot pass anything against you. He can reject your application, but he cannot decide anything against you. There are some cases where that SSC came up in the court and they say, see, they have rejected my application and therefore it is prejudicial to the interest. The court said, no, you cannot just because it is rejected, it is not prejudicial. So that they have also discussed. So this is one of the good beneficial thing that they have to decide in your favor. I have explained what you mean by the term order prejudicial to the SSC. Okay. There is no provision of appeal provided either to the SSC or to the department. The only remedy is to file an appeal, writ before the High Court. Department can also. So, but rarely I have seen in my list that they have ever given. Most of the time, I would say my experience 264, 90% of the cases, they reject commissioner. And once you challenge before the High Court, 90% of the cases are allowed. So this is the ratio, if you will say. You have to go through the process. What do you mean by records? Yes.
The 279 one order in.
Yes. Yes, you should. In fact, one of the cases is there where the SSC had directly gone to the High Court. They said that you can exercise 264. The only thing, as I said, the conditions have to be, because time and again the provisions are changing and the authority powers have been shifted from lower authorities to the higher. What you need to see that commissioner, it is not at the same level. If it is at the same level, then you cannot go. So there is always shifting. So that care you have to 179 where recovery proceedings are there against the director of a private company on that. In that, the courts have said you go to 264 and thereafter you can come down. So all this is you can exercise. What you mean by records? Records means everything that related to that case. It also includes anything the assessing officer finds out through inquiry, because subsection 1 authorizes the commissioner that on your application, he can conduct an inquiry himself or get an inquiry conducted through his officer. So anything, any material which comes out from that inquiry will be part and parcel of the record. There are few cases where it has come out that can a new evidence be allowed. So because let's take a case, it was a 143(1) assessment. So there will not be any material as such on the record what I have given before the assessing officer. In such case, I want to make out a case and I want to give some documents. Whether it will be treated as additional evidence or something like that, court have said that, look, you have to see a holistic view in this. If the claim is there and it is forming part of your return of income, some documents are there which the SSC produces it, you can very well verify that. Make an inquiry because the provision gives you the power. So make an inquiry and take those things on record and decide the matter. So the court empowers the commissioner to conduct an inquiry. And therefore, even if you case you bring out some material on record, that can be accepted and be considered as part of record. There is some contrary view of Andhra Pradesh High Court. I have given that also. But again, those are on different facts. You can always distinguish both the decisions, right? Application and procedure. So this also I have in detail explained you what is the limitation period and how this is there. Just to put briefly, your application, whatever you file, should contain, there is no particular format, but it should contain the detailed facts of the SSC, let me give you example of a mistake in the return. What is the mistake it has come up? It should be very crystal clear that this is the mistake. You should very specifically, clearly specify why this mistake has happened. Either it was a wrong interpretation, some factual aspect has not been looked into, or there was some contrary decision, or you had two views and you just skipped. So whatever is there, you have to give very briefly, explain those things.
Physically or electronically?
You have to file physically. If there is portal, I'm one goes to the commissioner and one copy will be referred to the assessing officer, to your jurisdictional commissioner. So this application, you have to give a brief detail about your case, why that mistake has happened, and what is the relief you want to seek. Okay, do well, ask for a personal hearing in the application. Whatever documents you want to enclose, make a proper index, compile it properly, and then you get it filed. Whenever the hearing notice is there, you will be entitled to go file your judgments. If you are having some judgments also in your support, enclose that, get it filed, go for the hearing, explain him your points, and thereafter let him pass the order. Okay, so date of the order also has been interpreted, because there was some dispute from when the date of the order has to be seen, because there are date of knowledge to the SSC when he became aware about the order. So from that date, that has to be counted. Okay. So again, here the commissioner has to pass an order within 1 year from the end of the financial year which the application is made. Non-disposal of the application, which is stipulated period, does not mean that revision was granted. So somebody had filed and it was not decided, they filed that you have not decided, that means it is allowed. No, it doesn't mean that. It is, as I said in the beginning, it is a directory provision that it should be passed within a period of 1 year. The order has to be a speaking order. So the commissioner cannot just say, no, I am rejecting your application. He cannot reject your application on some flimsy ground. So many times you say that they say that why you have not filed a revised return. He cannot question that why I have not filed my return. Normally, the time limit for filing the revised return is already gone. And I came to know, or I became aware, or I became a wiser person at a later point of time. And therefore, I have come before you. So you cannot reject me or push me back saying that hey, why you have not filed, or why you have not done that, or why you have not done this. If the commissioner can do it, he should do it. And he should not push me back saying that you go there and you get it done in this way.
It's 1 year from the end of the time in which the application is made.
So it is.
Basically, what is it called? The obligation on the part of CIT to pass an order.
Yes.
Must, it says must. And if the commissioner doesn't do that, what does it mean? I mean, then assessing is give particular time, you know, we are penalized.
Yes.
What about it?
So there are two ways. So there are in income tax, if you see, there are just like orders have to be passed, appeal has to be passed. The will be in nature. Excuse me.
What it says must.
You want this?
Yeah.
Thank you. So it is a directory provision.
Directive has to be complied with.
It has to be complied, but if you don't comply, it doesn't mean it is allowed, or there cannot be any punishment on the commissioner or something like that. It cannot be. If you see, the reason is that if you doesn't decide, then what does it mean? Is it rejected? Because it's your application. You are. So the question is justice denied, even if you go and shout in only in Supreme Court, not before the lower court. I was on the point of speaking order. So the commissioner has to pass a speaking order. He cannot just reject your application on some flimsy ground. He has to give a reasons in the order. Okay, subject to an appeal to the CIT appeal or to the appellate tribunal. That also we have discussed what you mean by subject to an appeal. If any subject matter is in the appeal, you cannot go for 264 and you have to go for the full order. You cannot go for partial. When we read section 263, the subject matter they can exercise if you have filed an appeal before the commissioner appeals on ground A, and that commissioner has considered and decided that particular issue. The 263 cannot be invoked on that point, but on some other point they can invoke. But here it cannot go partially here and partially there. You have to go against the full order, or you cannot go. So this is if one. So this is as far as the subject to appeal is concerned. No appeal or tribunal reference to the court. It is the same thing. Instance where the revision application will lie. So I have just list out some few instances where a return is rejected as belated without application of mine. We can exercise where certain items of income on which tax is deducted at sources are inadvertently omitted to be included, resulting in loss of relief to the SSE. We can invoke where the SSE has omitted to claim certain deductions, though all the relevant data are on record. We can invoke where the SSE has no remedy by way of appeal against the order in question. We can invoke where the SSE challenges the correctness of the assessing officer on a point which has not been contested before the AO. We can still go where SSE challenges the order of the assessing officer on the basis of earlier or later decision of Tribunal, High Court, Supreme Court, or otherwise. We can go where an order passed under 220 subsection 6 has not followed board circular, etc. We can still go to the commissioner. Revision can be made in respect of income wrongly offered in the return of income. So these are the few instances where you can exercise 264. Circumstances when the writ court will entertain a writ. This also I have discussed. I have listed down certain things, non-application of mine to the facts of the case by error or apparent face on record. It is passed without acceding to the appellant's request on an oral hearing. Commissioner refuses to consider SSE's claim or grant him relief, ignores the decision of jurisdictional high court or follow it on a ground that it has not been accepted by the department. refuses to condone the delay in making the revision petition when circumstances of the case calls for condonation, order should be reasoned one. So these are the circumstances when we go to the High Court, what the court looks into the matter. Because writ court has again a limited jurisdiction, it is not an appellate jurisdiction. So they will see limited on these counts, how the order is there and whether they can intervene in that order or not. Duty and powers of the commissioner, this is already there. I have explained this on the earlier point. He has to do all these rules and follow the act. Okay, pass the reasoned order. So this is as far as 263. Some of the important issues and decisions are there. I have listed down. You can go at your leisure. You can go through this. Something if new plea, commissioner to apply his mind even to a new claim and a new plea. So even if it's a new claim or a new plea, he should apply his mind and he can consider that. Okay. Return filed accepted by O, subsequently mistake is noticed. Answer is yes. As I explained you can file it. Whatever points I had mentioned on the same points, what are the relevant decision I have listed down here. So it is a repetition of that along with a list of decision. You can go through at your leisure. Wherever you find relevant, you can use them, but read the facts before you apply to your case. Mistake can be of the SSC himself and not necessarily that it should be of AO. So if it is your mistake, you can still file it. Sorry? No, nothing like that. Nothing like that. Should I cancel it?
No.
Minimize it?
Minimize.
He wants me to get stopped again. So he offered that particular thing and there was some specific change or amendment which was brought out and very specifically said that this is they are not liable to be taxed. Now this happened around 10 years back. After 10 years, when he came to know and his chartered accountant, I had offered and now it is clear position, then he immediately filed this 264 application with condonation. Now condonation for all the past 10 years of a different time. The previous first 10 years, it will be 10 years, the 9, 8, 7, 6 like that. For the last year, it was less, the time limited. But the moment the amendment came, he filed it within a period of 3 to 4 months and he approached the court. The commissioner first rejected on the ground of condonation and say that this amendment is only clarificatory in nature, etc. He read from the memorandum and he said and he rejected the application. When the matter went before the court, it was a bench of Justice Daga, I recollect. He looked into this and as far as the condonation aspect was there, what he said, see, when the cause of action arises for the SSC, when the amendment took place and he looked into that, that is the point of cause of action. So therefore, when the cause of action arises and then immediately he filed it, so therefore we should condone the delay. So he condoned the delay. Then he went one step ahead also. He said that commissioner has not looked into the merits and he had just commented and said, but if we read the provision of the act, it is very clear that this amount is not taxable and department is not disputing that point in the affidavit in reply which is filed before the court. So therefore he said that this also we will allow. So he got the relief in the High Court itself on merits also. So that is how the courts also looked at. Kalpesh M. Nagda was also a case of 80 HSC. There were many amendments, a DEPB license to and fro. It was a judgment was coming. In that case also he had not claimed. And when the petition was filed, it was rejected when it went to the court. We explained that there was a retrospective amendment and changes were there. Now he's entitled to it and he should get it. The court accepted that position and said, yes, it should be, why not? It should be allowed. Just because of the change in law, change of the provision which has taken place, he cannot be denied that benefit and it should be allowed. So at this, considering that situation also, you can file an application. So these are the different cases, whatever we have discussed. These are the different cases which you can invoke 179, sir, you had said. So this is the case of 179 also you can invoke. Okay. So I have listed down all the issues and the relevant decisions also. So you can go through it at your leisure. So with this, as far as 264 is concerned, we have completed this topic, and I will take up the next topic.
Sir,
Yes, sir. Yes.
we
Yes, sir.
have a CBDT circular, when you prefer an appeal,
Yes.
you have to pay 20% and the balance 80% is kept on stay.
Hmm.
Granting stay as per the CBDT. Sir.
Yes.
Any such leave when you apply for 264?
So I would advise that if such a situation is there, let me take an example, put it in as an example of a case that an assessment order is passed. There is a demand raised of say 1 crore rupees against the SSC. SSC has filed an appeal.
Yeah.
When you file an appeal, you also have within 30 days period, you should file a stay application. You should file a stay application, right? The first question is arise in your question, whether you have filed a stay application, yes or no. If you have not filed, then you cannot go directly to the 264. You should first go to the authority who is entitled to grant you stay. So first you will make an application to the assessing officer. If he rejects that application, then there is a remedy for you to go to the principal commissioner challenging that order. If you go to 264, again your doors, he will have this is a discretionary thing. If you read the CBDT circular, it doesn't mandate that in all the cases you have to deposit 20%. It says that if you don't want to pay, then you make out your case. You make out a case. There are many cases where we are able to make out a case that no, zero taxes is required to be paid because of the following this reason. And you say that you fix up my appeal, I am ready to argue. And in that situation, the commissioners are granting you 100% stay. So according to me, a best remedy should be in this route and not a 264 route. Where two views are possible, discretionary is there, why he will exercise in your favor. So it is better to take the assessing officer and then challenge his order before the commissioner.
Sir, what about prohibition?
1 second, sir.
The applicant for stay, what is the duty of the assessing officer? Can you first say you first pay 20%, then I'll give a stay order?
No.
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 So he has to pass an order asking you to pay 20%.
He has to pass your order why your application is rejected and direct him as per the CBDT circular, 20% should be paid or
Cannot first say you pay 20%.
no. There is no requirement that to consider your stay application, you are required to pay 20%. There is no such condition. Sorry?
Doesn't pass in the order.
So he cannot recover. So he till your application. So you should read the classic decision in this KEC International of Bombay High Court. You should read that judgment. If all you can read Mahindra and Mahindra Limited also. And thereafter, all the judgments are there which are following these decisions of Mahindra and Mahindra Limited and KEC International. So there in detail, the guidelines have been set out. Subsequently, all the decisions are following these decisions or laying down the similar guidelines. So these are the classic case where you should, right? Yes, sir.
Prohibition, can we go for 264?
No, in what stage you want to go against 260? What stage I am asking, which order you want to challenge or what you want to go? Prosecution is launched. It's always then you have to go to the criminal court, magistrate court. Where then how you will exercise? As far as sanction for prosecution is concerned, the sanction is given under section 279 subsection 1 by the commissioner. So therefore you cannot exercise 264 there also. And this is again a discretionary. Right? So let me move through this and then I will move to 119. We are already at 12:30. Okay. So I will not take it. It's your Sunday, half day is already gone. And then I am taking you through such a topic, relief. You are thinking, अरे अब जाके सब matter में जहाँ बचा था सब में relief लेना है. Okay. Anyway, this is a very good circular. If you will read the date of this circular, it's very important to see the date of this circular. It is of 1955. Okay. many times if you will try to find this circular, you will not find this circular also. But those who have the old commentaries, you will find this judgment. I don't know whether Taxman also has this circular. So this is a very old circular. So our act, what we are dealing right now, is an act of 1961. तो ये कभी था 1922 वाला एक्ट में था. उस एक्ट में ये सर्कुलर तभी इशू हुआ था. Basically what this circular says, I will just read a small one paragraph. The CBTT has way back in 1955 issued this circular as to what should be the departmental's attitude towards refunds and relief to the SSC. जैसे ये सेंटेंस हम लोग पढ़ते हैं कमिश्नर ऑफिसर के पास, वो एकदम चिढ़ जाता है. होता है 1955 का सर्कुलर, you are teaching me how I should do and this. The problem is, though this is a circular of 1955, but today also it is very relevant. Tribunals, courts are referring to this circular in various judgments. The circular is a benevolent circular which says that if I have missed something, what is your duty of the department? They should not take the benefit of the you have missed, so you are gone. I will not give you. You cannot do that. If I have missed to claim something, it belongs to you. You should be take this. You have to have this. Why? The question is why this circular? Then I will say that there is an article 265 in Constitution. Okay. If you have Constitution in your office, read this article, or if you will do Google, you will get it. So this article basically says that no authority can charge or claim any amount unless it is liable to be taxed under the relevant act. तो आपसे 1 रुपया भी कोई नहीं ले सकता unless the act provides to be charged. So this is the Constitution what is provided. Act is coming from the Constitution. It is the mother from mother. These acts are made by the Parliament. Acts cannot be contrary to the main Constitution. So the Constitution provides. Then in that context, if I have wrongly paid something, can the department enrich itself with this amount? Answer is no. They have to give back. There has to be a way to give it back or return back to the citizens. They cannot keep. This is what the circular basically says. That if you have missed, SSC has missed to claim some benefit, entitled to something, you should give that benefit and not enjoy that benefit with you. This is basically what this circular says. Unfortunately, department is not recognizing this CBDT circular, nor they are applying it while they are dealing with the case to case or matter. Okay, but
Provisions relating to updated returns, they are not accepting.
so
I pay no tax, you are 50% tax. It doesn't give any possibility of getting a refund.
So again, see, updated return is a different situation altogether. Updated return you cannot compare with the situations what we are talking.
I pay extra tax.
Yes.
I'm filing updated return.
So just because the taxi, you cannot apply that thing because they are saying they are not forcing you to file a updated return. Na? You are choosing to file a updated return.
Take it as the extra tax by mistake. One man cannot take any single rupee from it, not due. Right?
If that is the case, then you exercise a different route.
So what?
See, they are not inviting you that you file a updated return. Yes.
This is not being 25% by mistake, I get 50% tax, right? Now this amount, that doesn't say that I pay 50%, right? Tax says I pay 25%, I'm paying 50% tax.
Because you are going for updated return.
Now by mistake, if I pay more tax, this government entire take away the money from which is not legally due to them.
No, what are you trying to say that the rate of tax while filing an updated return is 50%, but you have
25%, but I paid 50%, I paid more.
I mistake, yes.
I mistake, I paid more amount.
so you are entitled to make a
Updated return policy doesn't allow any refund to be given.
no. So refund. So again, so something is this is there something where you have to interpret that what you have paid. You have shown an income of 100. As per the updated return, I have to pay a tax rate of say 70 rupees or 60 rupees or 70 rupees, whatever is there. By mistake, you have paid more. So at least that for extra, you can always make an application.
But what application? It's all done by CPC.
So make your application. Try this under 264. You should try it.
But there is no order being passed, they are just keeping it like that only.
See, that is a different thing. Your question is
One which I paid extra, Stuck up with the government. I'm not able to recover that money from the government.
So that's what I'm saying. So, and you are saying you have a case now. You have, if I put your case rightly, you have applied a wrong rate of tax, and you have paid under any particular provision, any other act. Are you entitled to refund of that? Answer is yes. So you have to make a necessary application. Make a necessary application with your jurisdictional officer, CPC, wherever is there, and see that they dispose of that application. Somewhere they will reject. The moment they reject, then you take the necessary steps for that. Okay, so these are the features of this that I have listed down. These are the few case laws where you will find this circulars has been referred, and they have been referred in favor of the SSE. So while dealing with 264 applications also, the commissioners are referring to this circular and they are giving relief. The courts have referred this circular and they are giving this relief to the SSE. Okay. So these are the few case laws which you can go through them at your leisure. Okay. Any questions is there on this? Because this is basically whatever I explained you under 264, something additional thing you can derive from this circular, right? So here, see, the Bombay High Court very beautifully in this case has referred that it is the fundamental principle of the law. Fundamental principle of law that no party should be prejudiced on account of any mistake in the order of the tribunal. The court further held that. So they have referred to this. So the basic principle behind enacting this circular was that somewhere the SSE has committed by mistake, he has missed out, and that relief should be given to the SSE, right?
Can you help to explain the process for this non-validation?
1 second. I will just open this. Yes, sir. What was your query?
Process for this non-validation, can you guide us?
Process of
This application to this non-validation.
filing condonation. So it is, see, it is very factual. I cannot say in general what should be applied. But as I told you, so when you are filing an application for condonation, you have to narrate why there was a delay. First, you have to narrate what is the delay. So your order was passed on so and so date. You are making this application on so and so date, and there is a delay of so and so. Thereafter, you go and try to explain, give your background. What is your case? Why there was a delay? And thereafter you continue and then you seek the delay. You have to show hardship also. For the why, what happened because of which reason you were not able to file. And if this delay is not condoned, then what are the other hardship you will face? So I will give you under 119, the topic there was, I will just come directly to the discussion so that I can explain you by example. So there was an SSE, it is a case of Smita Gule, it is reported in Taxman. So she is a doctor and she's a widow. Her in 2014, after her demise of her husband, certain ancestral property devolved on her family, which included herself, 2 minor children, and the parents of her husband. Somewhere in 2016, the parents, by way of some deed, release deed, they gave that all this property should go to the lady and the children. So she became the full owner and along with the children in somewhere in 2016 or so. Somewhere down the line, 2000, during the COVID period, just before the COVID, 2019, she sold that particular property. Okay, and the property value was quite exorbitant because considering it was a large piece of land near some Pune city. Okay, normally when she paid, the CM must have asked her to pay some advance tax. She deposited some advance tax also. But by the time end of March 20, COVID strike. Okay. And thereafter, all this continued, what we all are aware. Now, in this process, the last date for filing the return, which was extended from time to time, it reached to December, and thereafter 10th January, it was closed. So as an individual SSE, she was required to file a return by 10 January, but she was not able to file. Later on, she filed it in the month of March, and she had got this particular property valued through a valuer, and whereby the capital gain which came, which was a nil or loss capital gain was, yes, loss capital gain was there in her case. The delay was there of around 2 months or so. March she filed. She filed her application before the CBDT for condonation under section 1192 subclause. If there is some time given and you are delayed, then you can make an application to the board under CBDT to get this delay condoned and make your application beyond the particular time that has been under the act. And the board has to, subject to other circumstances, entertain all. He's asking me again and again to keep quiet. So, she filed all this application. A detailed inquiry was made because her claim was more than 1 crore, and therefore it was gone to the CBDT. As per the circular, there is monetary limits fixed. If it is a claim of 1 crore, PCIT, if it is less than 50 lakhs, then commissioner will see. If it is less than 10 lakhs, the AO will see. This monetary time limits are changed from time to time. Okay. So she had filed all this inquiry made. Finally, the order was passed rejecting her case and the two children's case that no delay will not be condoned. And the reasons were very weird. The reasons were like, you sold the property in 2019 before COVID. Why never you got it valued at that time? You are an educated woman, you are a doctor. You should have been aware of the provision of the act and you should have got this valuation done. Huh? No, she's an educated person. So she was, 1 second, sir, that we will deal with later. What he has said, I am not saying that officer had said. You don't put it. I was defending that. I was defending her in the court. Okay. So this is one reason. The other reason, they said that SSC has not produced any evidence to show that she had approached the chartered accountant in time. Some evidence or something. We had asked, said, sir, phone pe baat kiya tha or something like that. Then the question was that when you approached the valuer, and there is nothing on record to show that you had approached the valuer in time, and why you have not approached the valuer and got him. So one reason was there in one of the letters, what I had found, and I picked up that thread and I used it, that she had mentioned that the valuer is Mumbai based and he is 75 years old and he himself was suffering through some COVID and some lung disease, and therefore he had refused to come to Pune. And I had later on also I cross-checked and I found that that was factually correct also. So all these reasons was there, and then they rejected. Then they said that claim is also doubtful. There is a capital loss she's showing of this huge amount. Matter went before the court. We explained all that affidavit exchange was there. We explained the court that, sir, this is the reason. Now, see, there are some court craft also required when we go. There are different things also. We put up the case that this is on my ground I have seen. There is a debt in the family. She's a doctor. she was attending to COVID patients. Her family was suffering during the COVID. There was a property which came to her by way of inheritance. And all this is there. She will never understand all this complex issue of valuation, etc. Then I read the observation also where it said that doctor, she's a doctor, well-educated lady, and she should have been aware of this provision, all this. I'm saying that this is a hyper-technical view they are taking. They are asking something. These are the quote, after reading my first ground, they were satisfied and they just closed, and then they started that why you are doing like this to the SSA, etc. And they accepted the plea. And they condone the delay and allow the return to be accepted by the department. So the point what you were saying, how we should draft, we should try for the officers. So you very well aware how their department's mind is working. Keeping that factor in mind, you should draft your application. You should try to go to the hilt that he will question me this, then what I. So likewise, I have seen many times they say for condonation, why you have not filed, the order was left in the drawer and the article clerk missed. And then I said, hey, article clerk, give name, then they will purely pull one of the article from the office and they will give the reason. Don't do like this. Or you will give a reason that I was traveling. Where you are traveling, it is not mentioned. If the court will ask tomorrow, give me some proof of your traveling, then you will not have. Then you will say, no, I had traveled by car. I had gone to Delhi by car. So this is not a general way. The point is that you go to the end, that if somebody will cross question you, whether you will have something to prove. The supporting things and you should touch the heart of the person who is reading, because you are asking for sympathy. Condonation ho gaya, condone kar do. And you should show difficulty and your financial hardship. What you will face if the condonation is not allowed. So these are the few things that you have to weigh in your application when you are filing your condonation. That's it. So section 119 has two limbs, 1191 and 1192. 119 is very technical. It is just one point I will say. 119 is basically allows the board to issue instructions to the authorities about how to deal with assessment procedure and dealing with the act, all this act. The section cannot, there are two exceptions. It cannot interfere with the discretion of the CIT appeal in exercises appellate function. It cannot direct any income tax authority to make a particular assessment or dispose of a particular case in a particular manner. So these are very important things. You know, in between there was a action plan which was issued by the CBDT, which specified that the officers will be rewarded or something will be marked if they will impose penalty or dispose of the assessment in a particular way. Then Chamber of Tax Consultant challenged this before the Bombay High Court, and they said that no, this type of provision whereby you are giving incentive to the officer to see that the order is passed in a particular manner is not correct. And they struck off that particular whatever was there in that action plan of 1819. It is there. So these are the things how you need to watch and you should say. So we had challenged this and the Bombay High Court accepted this particular plea. Okay, so this is as far as section 1192 is concerned. Section 119 subsection 1 is concerned. Subsection 2 to do for avoiding genuine hardship. The word is used as genuine hardship in any case or class of cases. Any case and class of cases, it may be that it's a group or even an individual case will also be considered as a class of case or any case or class of cases. By general or special order, authorizes income tax authority not being Joint Commissioner Appeals or Commissioner Appeals to admit an application or a claim for any exemption, deduction, refund, any other relief under this act after expiry of the period specified by or under this act for making such application or claim and deal with the same on merits. So what it specifies, to admit an application or a claim for what? For any exemption, deduction, refund, or any other relief under the Act. So last word is important, any other relief under the Act. You cannot go beyond the Act and ask something. So you have to restrict yourself under the Act. Now, when you are reading this and you are trying to apply to your case, there are certain circulars I explained you. There are certain circulars which are issued. You have to again read those circulars, apply this provision, and thereafter make an application to the board. So the classic case are there where your refund claims are there. And as I explained you the case of Smita Gule, that case. This is an ideal case where you can apply in 119 and get your condonation. Case of a cooperative bank where the cooperative registrar appoints the auditor which is on their panel. Many times what I have understand that these officers are appointed late, the auditors are appointed late, and by the time they complete the audit, it's a bit delayed and their return is filed late. In that situation, various deduction exemption under 139 may be denied to you. So in that situation, you should correct your return by making an application under 119 and get your return condoned, the delay condoned, so that your exemption, deduction, etc. will be allowed. So it's very necessary, if your returns are delayed for any of such reason, you make this application and get your return, the delay condoned, so that your return are admitted properly. Yes, so there are circulars where they have delegated the powers to various authority. There was earlier a circular I have listed down in my note. There was earlier a circular of 2015 and thereafter it has come in 2024 also. It has come in month of some October or so. It has been updated. Okay. So there are provision for waiver of interest. So there are circumstances which are given under which class of cases the waiver you can apply. So there is a case of a search. There is a provision where you can make an waiver application. Any income chargeable under the head capital gains. There is a situation where you can make, or where an income is chargeable due to some change in law. So, for example, earlier there was a position of jurisdictional high court and thereafter the Supreme Court has reversed that situation. In that situation, now you are liable to pay tax and there will be an interest component also. So in such a situation, there are circumstances where the circular are given in what case you can exercise. Okay. So for 201 waiver of interest also there is a circular. So whenever you refer, and particular you have to also try to see the relevant circular in that context. Whichever is there, you have to use along with that. I have given few instances here whereby you can apply and how the courts will look into. So default in furnishing the return of income, bona fide family dispute entitled to waiver of interest. So there is so you don't use this because I have given in a very small compass that bona fide capital dispute, and you will say that a dispute hai, chalo apply karo. Don't do that. The facts are very important. How the facts was there, how it was put, how that dispute could be shown, and thereafter there are cases of companies where the directors are fighting tooth and nail. There are family feud that it goes to the court, and in that situation there was some delay, etc. Those are the ideal cases where you can apply for waiver and do all these things. Okay, not in each and every case you can just use this provision. I will just go to the 1192B belated claim. So yeah, so I am coming to this belated claim, power to entertain a belated claim. So 1192, if there is a delay and under the act you have not filed in time, the act doesn't allow you to grant the benefit. So this is the provision where you have to make the application. Okay, so this is the case of that cooperative society as I explained you, right? So this is the 2015 circular. I have listed circular number 9 of 2015, okay, which deals with condonation of delay in filing refund claims and claim of carry forward losses under section 102B, which has now been superseded again. So at that time, you will see the monetary limits were specified in subsection 2. That if it is less than 10 lakhs, then the principal commissioner or jurisdictional officer will see. If it is above than 50 lakhs, then it will go to the CCIT. It's above 50, then it will go to the CBDT. Okay, and there they say that no condonation application for claim of refund or loss shall be entertained beyond the 6 years. So this is very important. This they have given a time limit that within 6 years at least you make this application. If it is beyond 6 years, it is you cannot entertain. Now, if you will read the section doesn't provide any time limit. The circular provides this time limit. But when if you will go to the court will deal with a case where genuinely if you are coming beyond 6 years for some genuine reason, they will only entertain. It should be extraordinary case. Why 6 years? You know, earlier regime 148 reassessment, there is a time limit 6 years. From there, they have borrowed and they have kept it for 6 years. So it should not be that a person is sleeping over his rights and one day he jumps and wakes up and no, that person had come and he had given a lecture. I will file an application. It will not be entertained. Okay, so you have to see that there is some time limit also, and you have to specify, follow that time limit. Okay, for inquiries, for all this, everything is the important word if I had read is genuine hardship. You have to clearly specify what is genuine hardship, and it will always depend fact to facts. Question is whether financial difficulty is a genuine hardship. Answer is yes. Financial difficulty will also be a genuine hardship. So that you have to explain, and you have to also explain that if you don't condone this delay, my return will not be accepted, and what are the consequences that will fall. So in a case of a trust, recently there was one matter in a case of a trust that form 9A is required to be filed, income accrued but not received. So he had not filed it originally, but when the assessment was started and he found that there was some change in his taxable income, and now he requires that extra amount, otherwise there will be an amount which is taxable. So he at that time he wanted to file this form, but the window went in electronic, I think so from 16, 17 onwards. So he was, though he could have filed, but he was not able to file. He communicated this fact to the AO. He gave the working also to the AO, but this form was not filed. Because this form was not filed, the assessing officer passed the order without giving this benefit of form 9A that income accrued but not received. Normally bank interest, it is there in the case of a trust. So assessment order file, when he asked the SSC why you never did, so he said after the assessment order was filed, within next 3 to 4 days, there was a circular which permitted to file belated form 9A with the commissioner and so and so, and he filed it immediately within 3 days. This application was filed. Again, the officers, as they usually do, rejected the application, saying that you have an auditor, he is knowledgeable, you are trust, why you have not done this and that, usual. And this is factually correct also. See, you should have filed. So he made out his case. He said that this was a mistake and it all happened because my original return was nil. I was not required to take this benefit. Therefore, I missed to file. And it is a mistake on the part of the trust, but it should be accepted. When the matter went in the court, we made a computation. I started looking into the matter in a different way. I showed the hardship, what will be caused. And I explained her there at that time in the course of the assessment, there was some additional points which were noted, and because of it, the income from nil turned out to be a positive amount of 57 lakhs. And now this 57 lakhs is going to be taxed, and the trust will suffer. If I get this benefit of somewhere around 45 or 50 lakhs, then my taxable income will be very small, and the tax amount will be hardly a lakh or two. So if this benefit is not granted, then I will be suffering hardship. And I am a case of a trust, and otherwise I have complied everything. But this is what something is there. And being a trust, this some leniency should be shown. Court accepted immediately and say you don't apply a hyper technical. If they are entitled, give them. There is a delay, they are admitting their mistake. Now what else you want? So the court allowed that relief to the SSC. So that is what the approach of the court is there. But you should never use this judgment and try to take it leniently. In that case, it is allowed. So in my case, it should be. You have to always try to make your application best to the hilt, that even if this officer will reject, I have to go to the court and how court will look into it. Okay, so many times, many things you don't see in the judgments, but in the background, many things go on. So when I was dealing with this judgment of the trust, I clearly found that the auditor had committed a mistake, and they didn't have any explanation to give me, at least in front of me. And till last moment, I was saying, I am not sure what will happen. Maybe the auditor will be called and he will be asked that you take the responsibility. So, but when the matter came up, the things went in a different way, and we were able to convince that everything is very clean. We are coming with clean. There is a mistake. It happened. It happened, the mistake, and now it should be allowed. So the point is this, that this is how the courts look into this circular and they grant this relief. So for condonation or delay in filing, there is in 2023, there was an updated circular of this 2015 was again updated. And on 1st October 2024, I was mentioning, this is the latest circular. You can see first circular number 11 of 24 dated 1st October 2024. This is the updated. But when you are reading this circular, you do read the 2015 circular, read along with that. So you will get an idea how, what was there, the condition and how it was looked, and how this 2015 circular has substituted. So it is not a new circular altogether, it is substituting the earlier circular. So it's borrowing the things from the earlier circular. Okay. So there are other circulars and instructions on different issues. For in the case of a trust and all these different issues are there, and they issue this circular from time to time for condonation. So condonation for under this, all these circulars are there. ATP also, there are circulars which says that because after 1819, you are not entitled to get a deduction under ATP if your return is not filed in time. In most of the societies and trusts, you will find the returns are delayed. So if it is delayed, you will lose this. And many times what happens, I see that the SSC makes an application before the AO. AO is not the authority to condone the delay. And if the AO is not doing, they file an appeal and ask the commissioner to condone the delay in filing the return. Commissioner cannot grant you this relief. You have to make an application under this provision with the specific authority for condoning the delay in filing your return of income. Once your return in income condonation is condoned, then you are automatically entitled to this relief. Refund application condonation in filing return of income and claiming refund of TDS. So anything is there, you have directly the jurisdictional Bombay High Court, which says that you are entitled to this particular refund. Genuine hardship, condonation of delay, matter remanded to the board to consider the application in a proper perspective. Okay, so here was a case, basically the matter was dealt, the circular authorizes specific authorities to deal. So if your claim is above 50 lakhs and now it is 1 crore and above, CBDT has to see. Though CBDT is the highest authority, North Block में दिल्ली में रहते हैं. So वो लोग क्या रहता है, application तो वहां जाता है लेकिन order pass करते हैं कोई secretary or so, and the order it is mentioned that so and so of so and so with the approval of so and so this order is passed. When the matter came up the court said no, you cannot do that. You have to pass the order. You cannot ask your officers or your this secretaries to pass the order. And the order is signed by those persons. It mentions that it is passed with the approval of so and so authority, but not by that authority. So ये बहुत technical निकाला और इसमें किया, and the courts have said no, the order is not properly passed by the specific authority which is being directed as by the circular. आप सुनेंगे और ऑर्डर कोई और पास करेगा तो नहीं चलेगा. You have to pass the order. So it is a decision of Bombay High Court in the case of R.K. Madani, very good decision which deals with this particular provision, and they remitted the matter back to say that you have to decide the matter afresh. Central Board of Trade, refund of tax, deduction of source, condonation, rectification, requisition filed after 12 years from the relevant year. Here is barred. Yahan court has said your writ petition is not maintainable and rightly it is rejected. So here the person came after 12 years to claim that refund and said that no. Here also it is a genuine case. Everything is correct, but you are coming after 12 years. See, limitation basically puts an end to time. A particular list, a dispute which is there is some time limit. Yes, beyond time limit you can come, but not in all circumstances. Otherwise koi dispute khatam hi nahi hoga. Now, people will wake up at their own time and they will come and say you consider. So at some place,
the fixing tax payables from 3-4 this may take 5 to 7 21 years.
It's not time for the government tax.
So far as government is concerned, they are not. But last they have come out now some finance meter that as far as the old one is concerned is yeah, it should be closed and something is there. So they have also realized to some extent they are giving that benefit. So this is a system. See, these are the system where somebody should challenge, somebody should go to the court, somebody should do it. Hardly people do it. If you say that return filing ka audit ka tha, to who goes? Hardly few people, so few associations challenge and go reach to the court. ICDS is there. Yes, sir. So who again? Chamber had taken it to the Delhi, and there we are. How the things see benefit is to everyone, but you might not be knowing how people have worked behind the scene, who have appeared, what is the cost, what is the time, what people have given. The lawyer who had appeared in this Ganesh, he had appeared pro bono in this matter. People used to travel from here and attend in Delhi, and it was not in one hearing. Many times it has happened. So you should recognize this, how associations are appearing and doing this cause for it. Yes, sir. So as I said, this circular specifies as per the monetary limit where it has to go. So it is better you see your monetary limit and then file it. In case there is some confusion, I would suggest you file with your assessing officer, your commissioner jurisdictional place, and send by registered post to CBDT. Don't send it by courier. So there was a case of some Nasik where the client had sent it by courier. And thereafter the issue that we have not received your so though he had all that it is delivered, but courier received is not a proof under the Evidence Act when you go as far as government, and Indian Post is a proof. Chairman. And you have CBDT chairman email ID also. So you can file. So nowadays we have email ID of your assessing officer, your commissioner also, and this. So you should put it there also, as well as you file a physical copy. And when you are making this application, you can always put in the last line in case you have a confusion that where it will lie. Then you can mention that I am filing it before. In case you find that this application needs to be put up before a particular authority, you may forward this or direct us to forward the same. Okay. So at times, there are certain times some issues which are not crystal clear from this circular because they don't envisage all situation. They have envisaged certain class of situation for which they issue circular. Like I have one case where the matter was before BIFR. Okay. And the matter went on for a quite long time. I have 5 minutes now. Yes. So the matter was before BIFR for more than 10-12 years, and the SSC was enjoying all the benefits what a BIFR was doing. But in this 10-12 years, the implementation of whatever the plan was there was not done completed, but they were acting on the basis of whatever the creditors and with the bank, and they paid them. They had a plan of getting a company merged and the losses would be adjusted. All that they had planned and they had executed that also. But 2016 BIFR was closed, SICA was repealed, and all the matters which were there, they could have gone to NCLT. But because they had paid all their creditors and everything, they became a positive company by the year 2015 and 16. So they could not have gone in this. And the hearing which came, the hearing came in 15, 16. They went in the court also directing that my hearing may be completed, everything. But by last date of the year, the hearing was not completed. And thereafter, everything was closed. Now, all the plans, whatever was there, because it was not implemented, accepted, it never got executed. They are out. Now, what to do? All things went off track. The company who had sold and given the amount, they are now on their own. Reverse merger, what they had planned, they had not done that. So all this was there. And there was tax implication, 41(1) and all this thing. Now they came, they applied to the CBDT and said, you give me the benefit what I was entitled to, and at least allow me carry forward of the losses, which was crystallized, but not. We explained to that yes, see, there was an exchange of letters, reports, and department also has objected to this, but ultimately they said we will consider. Their point was not to allow but use the word to consider and not to allow. So that it will be considered. Once it is mentioned, it is considered. Only the implementation was not accepted because the act was repealed. So therefore, CBDT should look into it. Now, this particular situation is not there anywhere in circulars or the act. We are before the court asking that CBDT in such matter should exercise, because it is not because of me, but because of change of provision of law where I am suffering. And once all the facts are on record, you should consider this and try to allow this claim. The matter is still pending. The difficulty is that can the court allow a relief beyond the provision of the act? That is a moot question. But the other thing is that something which is crystallized, why not you should consider it? CBDT has power to consider it. Maybe the act doesn't have, but CBDT can look into it, because we are following in a class of cases, and in an individual SSC may be also considered as a class. Let's see what happens. But these are sometimes situations where people approach under this clause also. Here also it is a case, CBDT delay in filing return application for condonation was filed after 16 years. Delay was rejected. So there are people, again, this was before the Bombay High Court. So huge delay of there, and the court say, no, we will not entertain. Okay. So refund application, refusal to condone the delay and denial of refunds adopting hyper-technical view was held to be not proper. So this is also how the court looks into it. Okay, delay in filing the return due to late appointment. What I explained you, due to late appointment of statutory auditor must be condoned. Bombay Mercantile. So here also it is a case where the auditor was appointed late. So at that time, this is a old case. So once your return is filed, you have to. No, see, online it is permitted to some time. Now you will file under the 139 4 or 5. You will file. You will file a belated return. A particular period. If that period also expires, then you will make an application to the board asking to allow me to file the return. Whatever. They will give a direction to allow your return. So I will tell you. Yeah, I will tell you, this is a practical question. What you asked, very relevant. In Smita Gule, the last part of the order directed the assessing officer to open the window to file the return. Because you put this question, then immediately I strike. In that case, they allowed me. Then we went and filed the order. Then the officer, through his PCIT, got the window opened, and then the window was open. Then the SSC uploaded that return.
Next website, under SSC login, you can file the return, but you have to give the order number also. Then you are allowed to file the.
Yes. So that 119 application. So once you make this application, you have to ask for this specific relief also. Ki my return is not, I am not able to file, considering the change of position. Now you are not able to file the return. Your return is there. You should enclose a copy of your computation or return form, whatever is there, and ask them to permit to window the open so that you can file the return. Whatever the opening system is there. So that situation had arisen in that case of Smita, and the court had specifically mentioned open it within next 15 days, and SSC should file this return within so and so time. So all was there. Okay, so what I have done, I have again listed out the cases situation, and I have given the relevant case law also. So belated refund claim filed by an SSC, in every case of delay, there might be some lapse. Now this is very important. You should keep this judgment. In every case of delay, there might be some lapse on the part of the party concerned. That by itself was not ordinarily sufficient to turn down the plea or to shut the doors against him. So this is how the court looks into it, because it is a matter of condonation. The courts are liberal once you provide a proper and sufficient reason. Return of income delays or audit report not issued in time. Again, ATP related issue, courts have condoned and said that the condonation of delay in making return. So accordingly, that National Highway Authority that it was not issued in time, and therefore it was not financed. So they said that delay was not on the part of the SSC, and accordingly it was allowed to be. Discretion to admit claims made beyond the specified way is to be exercised on sound lines. So it should not be just rejected, but there has to be a reason and speaking order, and they have to deal with that, why it is not accepted. So genuine hardship also, how courts have looked into this term, genuine hardship is, I have explained. I think so. We are 115. Just I will cursorily go through it. This is a detailed article. Decisions are there. You can read that at your leisure. I have given some instance also how the application under 11 will lie in what situation. Okay. So these are there and some decisions are there. So you can go through it. If any query is there, I will entertain this query. Already we are 115. Yes.
Can be filed against the.
Sorry.
Whether we can file appeal.
Once this order is passed, then you can go in writ petition only before the only writ petition. Yes, no appeals.
But can not immediately.
No.
Can it be considered in the 264?
No, yes, 264 any order which is below the commissioner.
Present situation, they are giving authority of particular one.
That is a delegated power, sir. It's a delegated. I am there. I have to exercise 119. I have delegated the authority to so and so. So it is a delegation of power by our authority. The assessing officer himself doesn't possess that power. It is a CVDT order which is delegated to the lower authorities, and therefore he is dealing with that. So against that order, it is not advisable to go in 264.
I read one article where they said if it is passed under 119.
According to me, you should not do it because it is a delegated power through a circular which is given to the assessing officer. Otherwise, the assessing officer does not possess that power to pass that order.
Here, in the case of society, only for.
Because what will happen, you will file this, then the commissioner will sit as a appellate authority over the CBDT while dealing with that particular order, which he is a lower authority than say, he will never go against him. No, only writ. Yes, yes, madam.
Drafted at such a way that officer is like very hard. So is there any tool or any application or any tool?
AI might be there a tool I have never exercised. But people do use it. So one of my juniors showed me once that sir, this writ petition आप इतना time लगा दो, इसमें आप feed करो, देखो writ petition ready होता है. So I saw once. So सच्ची में आ गया, but it was not that way. Something is required, but there is no such format as such. You should go by read this view of this decision, and accordingly you.
Like the excellence in drafting.
Madam, this is only by experience and drafting again and again. If you get some good draft of submissions or this application, keep it in your file. That is how I have learned. And because I know whenever I used to draft and I used to give my senior, he used to cancel everything. And again it should, and then I used to feel like same to unhone bhi bana ke diya. But this is only by way of experience and time you learn and you improve upon. So drafting is not something where you will learn it by reading books, or that it is you read, try to put your points, get it experience. Yes, I have not included that, I have not included this, I should have done this, and you improve upon it.
Or something.
No, something I will say, whenever you get a good application format, so somewhere or the other, you will get it in your practice. So always keep a draft with you. So.
And he revises his order if some mistakes are pointed out.
No, commissioner under 263, no. As I.
Can he again modify his order?
So if something mistake is there, see, if there is a mistake, there is always an inherent power with a particular authority to correct its mistake. But it is not a power to review its decision. So if it's some clerical mistake, arithmetical mistake, any authority will have. This is an inherent power which is vested with the authority to look into if there is a mistake. But they cannot revise, they cannot reconsider. You cannot ask them to revise this order. So there is a difference between review, revision, appellate authority. So they cannot revise, they cannot review their own decision. And any administrative authority cannot do that. Yes.
There is a omission of considering the facts on that point.
then it is better that unless that authority permits you to file a fresh application, then you can try it by filing a fresh application, saying that my earlier this is a mistake or something, and he should accept it. Very difficult proposition, but if you have a case and the officer is accepting, then he is over than Supreme Court. Then nobody will question that.
Okay, we have just a quick question last. Yes. Please.
Yes.
Practically, when we file an application for condonation under section 119 to B, once I file an application, is an assessee granted a chance to
Yes.
file addendum to the application, say for example,
Yes.
if the mistake of
Yes.
the counsel and the consultant and an affidavit to the same is produced?
Yes, yes, you get a notice, and in that notice you should improve. So, for example, what you are saying, that it comes many times what application is filed, and when it comes for the hearing, at that time you feel something is omitted, something is missed out. You can always improve upon that.
Physical hearing is given.
Yes, there is a hearing given. You get a notice for hearing, and you should insist for hearing in your application. And if your application is there, always you can add on or give an addendum, something extra in your application. You can always do that.
This time is given for natural justice and already is passed before the notice is issued.
So we can have another session on what is natural justice. So friends, these are never-ending questions. I understand. These are all administrative related issues, and these are some connected with legal issue. And I understand after so many years of practice, what I speak here and through these judgments and what practically happens in the department is quite different. But these are the way how you have to put it across. I see that many times cases are resolved at the administrative level. But if the cases are not resolved and you have to travel to the higher forum, how the courts are going to look your pleadings, whatever has happened at the lower? Because when we go to the high court, I cannot make out a new case altogether. I can improvise your reasons, I can improvise or give a better explanation, but I cannot change your facts. I cannot change your reason. The point what I'm trying to take out from my talk is that once you are before the lower authority, put the facts, put the correct facts, put the reason that it should hit the person when he's deciding. It should be difficult for that person to reject that application and say, no, I will not. And if he rejects, still he rejects, then we have certain safeguards which is there, which we can use it before going to the higher authority. Thank you, friends, for giving me a patient hearing. Thank you very much.
Satisfaction on all the members discussed. Yesterday we had a similar kind of situation. So it is my privilege and honor to hear proposing a article like this. So I wish to express my gratitude to our convener, deputy convener, and the RCM for such a wonderful session. So I, on behalf of express gratitude and hearty word of thanks to for such a wonderful